Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today it has come in the press that Justice C.H. Manavendra Roy of AP High Court ordered the DGP to give instructions to their subordinate officers not to register FIR under section 107 CRPC. So he has asked the DGP to give administrative instructions to all the subordinate officers. So not to register FIRs. Why? So this is based on the writ petition filed by one B. Bandi Parashuramudu of Anantapur District. Actually, in ATMAKUR police station of Anantapur District, a case was registered against him under section 107 CRPC. This is the problem. So the court discussed that FIR has to be registered under section 154 CRPC. So 154 CRPC, what does it say? As and when the officer in charge receives information regarding the commission of a cognizable offence, if given orally or in writing to an officer in charge of police station, it shall be reduced in it. So commission of a cognizable offence. What is 107? 107 is only a security case. That is security for keeping the peace in certain cases. So whenever the executive magistrate is he is satisfied on information that some people are likely to commit breach of peace or public tranquility or to do any wrongful act, then he can ask them to execute bonds to keep security or peace for a certain period. This is the crux of 107 CRPC. Why police register cases under section 107 CRPC? Of course, please remember, it is all for administrative purpose. You may be knowing, there is a police manual for the police department. So as per order number 410, as per order 410, sub order 2, it is very clearly stated that offences we can call under section 41, cases under section 41, 107 to 110, like that, they can be registered under the pro forma of FIR, but they should not be assigned, they need not be assigned any number. That's why previously, when we worked as police officers, we used to maintain a duplicate FIR index. The purpose of the duplicate FIR index is to assign separate numbers for these things. Of course, in that duplicate FIR, we used to write the original FIR, all FIRs, plus these things like 174, 107, whatever. Likewise, missing cases. At the time, missing cases also, we did not register cases. Only in the FIR form we used to give them. But ultimately, instructions have changed because a case under 174 CRPC may turn into a murder case and investigation has to be taken up. So if you don't do investigation in the beginning, so normally material evidence will be lost. So that's why we used to register FIR. That is the intention. So administration, for the purpose of administration only, these 107 FIRs are registered. But of course, since the court has stated, this is not the first time for the court to tell that you should not register cases under section 107 PRC. If you go to, I think if I remember well, it is G. Rajshekar Reddy versus State of AP 2005. There also, the combined Andhra Pradesh State High Court Justice clearly stated that you should not register the FIR. Of course, it was a very big problematic issue in Gadwal area. So one Sai Baba, municipal chairperson, he died. His wife, Rama Sai Baba, I believe, she wanted to construct his statue. The next government did not agree, and she has gone to the court. First it failed, and second review petition. The review petition, they said that except Rajiv Chowk, you can install it anybody. It was kept lying in the municipal office ultimately. So two groups have formed, and in that connection, 107 CRPC was case registered. So there also, in that case, Supreme High Court said no registration of FIR. If you go to Tamil Nadu also, there are number of instructions, number of instances. So the only legal point here is what you have to know is that 154 FIR is used for cognizable offence. Here it is only presumption. That's all. If if the executive magistrate receives information that there is a likelihood of breach of peace, which may turn into a cognizable offence, so in that circumstances, he can ask them to execute bonds. That's all, not the FIR. So strictly speaking, it is FIR cannot be registered, but administration say that it can be, the FIR form can be used, but no number need be assigned. So normally police people, they think that unless you assign the number, the impact will not be there, therefore they register the FIR. So this is the actual legal point in this so-called scenario 154 and 154 CRPC and 107 CRPC. So this is the difference. If any police officer sees it, please read that order number 410. Definitely you will get 100% because APPM is not against to the law. APPM is in consonance with the law. Basing on the law only, APPM orders were framed. So it will not go against. Anyway, if the DGP gives you clear instructions, it will be well and good. Thank you very much.